This is the first in a series of training and events that we're doing on preventative measures. Now, you might say to me, Eleanor, you're a contentious probate lawyer. Why on earth would you want to prevent there being more work coming your way when there's disputes in estates? Well, the fact is that even though that is what we specialise in, that is our work, that is all we do, we work with real people, we work with real issues, and the purpose of our role and our involvement is to be problem solvers and to try to help people in extremely difficult and emotional circumstances move on with their lives to some extent. That involvement is much better, much more effective, much cheaper, much less stressful if we can make sure that that involvement and that input is at the beginning of a dispute, or at least at the early stages. This is because disputes are long running, they're stressful, they are costly, and they can absolutely put a hold on people being able to grieve their loved one. Similarly, for our referrers and the businesses that we collaborate with, it puts a stop on their ability to conduct their business. It means they're not getting paid. It means that administrations are basically held up and stopped until such time as the dispute is resolved. So it is in our interest and in our clients' interest and in our referrers' interest for there to be as much early preventative mitigating work as possible. So that's why we wanted to touch on that today. It is also somewhat of a shameless plug for our IDRN, our IDR network. Some of you will be members and that's how you've come to know about today's talk, but some of you aren't, and we'd really encourage you to join. It's a free resource. It's provided by qualified lawyers. It has masses of information on there, which is drafted and prepared in such a way that it's something that can be shared with your own clients or your own contacts. You know, it is in our interest as much as it is in yours to make sure that people go into disputes or go into, you know, inheritance issues with their eyes open and an awareness of the way in which we work. So just to touch on some of the most common contentious issues, what I wanted to do first was just take you to the triage section of the IDRN. So I'm just going to share my screen now so that you can see the relevant section. And this is what we're looking at here, the triage section. This is like A&E. This is what we see all the time, and this is how we deal with those really common issues. There is a number of sections here. There's the disappointed beneficiary section, caveats and Lark and Nugis requests, executors can't agree, and charity will legacy challenges. Today, I'm just going to touch on these three. From my perspective, the charity section could have a whole day's worth of training just on its own. So we're going to focus on these ones today. And I'm just going to talk you through our approach on those, give you a couple of legal insights from my own experience, and just, you know, an understanding of how those types of claims come to us. And then what I'm going to do is hand over to Laura just to talk to you about how we deal with the initial call or the initial approach from a client or a referrer, just so that you can see the different ways in which we manage the approaches, how we manage that first contact with either referrer or client, just to give you a bit of insight into that. So there will probably be some questions as we go through. It will probably be better if you put those in the chat for us, and we'll do a Q&A at the end, because then we can pick up on anything that's sort of duplicated, and it may be that that actually if there are questions at the end that a number of people are asking, we can touch on that as more of a substantive discussion. First of all, I want to go into the disappointed beneficiary section. What I will do is just share the PDF that is downloadable for this. This is something which you can download from the IDRN. It is something that can be shared with your clients, your colleagues, and it's also just a handy reference guide. Disappointed beneficiaries for me seem to be the majority of the inquiries that we get. These approaches tend to be relatively soon after somebody's passed away. There is, an element of shock and a misunderstanding about why they might have been left out of a will, why somebody has not made provision for them, and there are a number of different categories of potential claimant who might be able to go to the courts and say, this will does not represent what obligations the deceased had during their lifetime, or if the deceased hadn't left a will, the intestacy rules do not apply to these circumstances, and I need financial provision from the deceased estate. Essentially, the way that these claims are conducted is about looking at the claimant's relationship with the deceased during their lifetime. Commonly, we see cohabitees come to us where their partner has died. Because they weren't married, they don't enjoy the benefits of, passage of property, for example, or other sort of automatic rights that they may have had. Similarly, for example, in the intestacy rules, as a spouse, you are able to inherit if somebody hasn't made a will, and there are provisions for that inheritance. If you are unmarried, even if you've been with somebody for 30, 40 years, that it doesn't apply to the intestacy rules. There is no such thing as a common law marriage in those circumstances. And because of that misunderstanding during the lifetime of a deceased person, we do see many cohabitees come to us and say, but we were effectively man and wife, and we shared everything, and that this is wrong, that actually I should inherit nothing. And that is what the law provides. It provides an opportunity to bring about some fairness. It provides an opportunity to seek that financial provision that ought to have been put in place. And that is really the approach that the courts take. It's what should have been done here. If this was being looked at with the benefit of legal advice and training, what ought to have happened, what methodology ought to have been put in place to make sure that this person was provided for. The important thing to note with these types of claims is that there is a very strict time limit applied to them when after the grant of probate or the grant of letters of administration has been obtained. It is 6 months from that date, which may seem like a long time, but in the initial stages of an administration of the estate, it flies by. There are plenty of steps being taken by the estate administrators, which will take many weeks, if not months, at those early stages. So that time can be lost very, very quickly. If any personal representatives, executors, are put on notice of a potential claim, or indeed if they think there might be a claim, if a will has been located and it does leave out somebody that had that important relationship with the deceased, either as cohabitee or as a child of the deceased who isn't being provided for, then they ought to be aware of these provisions and the potential for a claim. We will often have approaches from executors or personal representatives who say to us, well, what do I do? Do I just put everything on hold? Well, the answer is that you should be doing your duties, you should be collecting in the estate, you should be making those inquiries. But equally, you ought to be aware of the types of claims and the potential for them. And essentially, it is the distribution of that estate which ought to be put on hold pending the resolution of any of these claims. It is generally understood and best practice that in the administration of estates, that distribution doesn't tend to happen for 6 months. And that 6 months is to take account of any claims being lodged under this Inheritance Act. The danger in distributing the estate before that time is that the estate is gone, it's lost, and any claim by a claimant will need to then involve some recoupment of the inheritance paid out to beneficiaries. It can also leave the executors personally liable for any distribution that's taken place wrongly if they knew about a claim that had come in. So it is an important 6 months, and it is an important time for both executors and any potential claimants to be gathering as much information as possible and to be making sure that any claim is notified, it's set out in as much detail as possible, and that there is some extent of communication, exchange of details regarding the estate, so that if there is any scope for settlement, then that can be done quickly. But equally, even if there isn't any scope for settlement, every party is aware of what the estate contains and also what the claimant is seeking, so that if the matter does have to be taken to court, the right people are bringing the claim, the right people are defending the claim, and the court has all of the relevant information. Given the 6-month time limit, it also bears noting that obviously if a grant is obtained relatively quickly after somebody dies, the 6-month time period is a time in which people are grieving. The bereavement aspect of this that we are mindful of is that often people aren't in the right place to be, pulling together bank statements and financial information. So it really is incumbent on the professionals involved to support any claimants through this, and to support any lay executors who also may have been close to the deceased and are grieving, to make sure that they are complying with their obligations and also bringing together all of the relevant information. So just moving on then to the next section here, I'll just bring that up. So the first one, this is the Lark and Nugis and caveats section. I'll quickly run on through caveats because caveats are both a help and a hindrance in disputed estates. They are a great tool to bring the estate administration to a halt, because the caveat being placed on the estate means that no grant can be obtained. It will often force people to engage in negotiations. It will force people to take claims seriously. But also it can be a hindrance. And the reason for this is because if somebody is lodging a caveat on an estate, the cost is very minimal. It can feel like something that is done just for the sake of doing it, rather than it being something which is applied properly to the estate, and is something which is justified in the circumstances. And just looking at this quick guide here, ultimately, this is the point that I often see as a hindrance with caveats. A lot of time, lay clients will approach solicitors and they'll say, right, get a caveat on the estate, get that put on straight away to protect your position. Well, it does protect their position, but what it does mean is that executors and personal representatives are then put in a position where they can't take steps to obtain the grant, Where there is a 1975 Act claim, the Inheritance Act that I've just been talking about, that will mean that no claim can really be issued, because ultimately you need to understand who is dealing with the estate, and have an idea of how much what the estate's value is. Both of those pieces of information are contained in the grant. And if you're not getting that engagement with the estate and you're not getting that information, the caveat can really just be sat there as a huge obstacle. It is also a hindrance where caveats are lodged without any sort of justification at all. Primarily, we see this where somebody is just unhappy with the contents of a will. They just want to cause trouble. They want to obstruct things. And for the executors or the personal representatives, that means that they have to look at making costly applications to remove those caveats, and engage in correspondence with people. Our approach is generally that if a caveat does not appear to be justified and we're not getting any information to justify it, then we will have that caveat removed. Because we deal with this all the time, we can do that quickly and cost effectively, so that it frees up the estate to get the grant move forward. But it is something that can be misused, but equally it does have a very important place in stopping rogue executors from taking on an estate, distributing everything before the claimant has an opportunity to actually bring their claim properly. The next part of this section is Larkin Nugis. Now, it's a funny name, and it always comes up in the sense of, what does this mean for me? Why has it got a stupid name? And how do we, how do we deal with this? This is something that we come across a lot. The Larkin Nugis request is a request of somebody who's drafted a will. It talks about the circumstances surrounding the will, what the testator was like, what their responses to certain questions were. The reason it's called a Larkin Nugis request is because that's the case which set out the rules for drafting solicitors in responding to requests for information about the circumstances surrounding a will being made. Typically, these are made in situations where a claimant may have concerns about the testator's mental capacity, or even if they were being unduly influenced into making the will. There are often very common and very real situations where somebody has been coerced by somebody who sort of infiltrated into the deceased life, maybe a carer, maybe a family member who has really just taken over, isolated the deceased, influenced them and persuaded them into putting things in their will which actually they may not have wanted to do, but because either they were told things that weren't true, or maybe they felt that if they didn't change their will, then this could be problematic for them. Maybe the care would stop, or maybe they'd have to move to a nursing home. Testators will do that, and they will find themselves in a situation where they are signing a will which truthfully wasn't really what they wanted. The purpose of the Larkin Nugis request is to say to the drafting solicitor, what happened here? Who was it who came with the testator? How did they appear? Were they did they feel comfortable? Were they happy around this person? Did they seem well in themselves? Were they forgetful? All of these sorts of questions ought to be noted by the drafting solicitor, and in detailed attendance notes and letters out to the client, sort of discussing what their wishes are, and making sure that really the will drafter is getting those wishes right and making sure that they are the true wishes of the testator. So, strange name, but very, very useful purpose, something that we will often be approached on, either to make those requests or to assist those solicitors who receive a request. It can feel like you are being challenged on your work. It can feel like you're being accused of doing something wrong, and often it's something that solicitors will just want a helping hand through, just want to talk things through and just make sure that they are complying with their obligations, but equally, you know, making sure that there isn't anything that they need to be concerned about themselves. So that brings me on to the final section, which I wanted to talk about, which is the executors can't agree section. Now, this isn't sort of something which we sort of shy away from. There are some very real situations in which this is not just about petty squabbles. It isn't just about who's signing what document. It is about genuine disputes between executors over the administration of the estate. The role of executors is a neutral one, and is one that it can be very difficult to comply with if you are somebody who was close to the deceased, if you have some personal issues with the beneficiaries. It can be very difficult to separate yourself from that. And so we do see that personal difficulty coming through, which can lead to disputes and can lead to very serious fallings out between the executors. That sort of situation does not serve the beneficiaries, and ultimately the executor's role is to act in the best interests of all beneficiaries in administering the estate. So the way that we would approach a dispute between executors is to do some fact finding. We would want to understand the basis of the dispute. We want to understand whether this is about one of the executors also being a beneficiary and potentially having a claim, or feeling left out of some arrangement that's in the will, or some trust arrangement that might have been put in place. That can often come about with siblings who are appointed as executors, where there are those personal historical issues which get in the way of them acting with that neutrality. Similarly, we will have the situation where there is a professional executor appointed alongside a family member. So a lay executor and a professional executor. We often see the lay executors feeling marginalised and feeling pushed out of decision making. We will see them almost trying to challenge the behaviour, the advice and the conduct of their co-executors, because they either don't understand the approach or they feel like decisions are being made without their input. That can be pretty difficult to resolve, because the way that the court resolves these sorts of disputes is to appoint an independent administrator to step in. Those independent administrators are professional executors. And what then happens is that those professional executors will charge their fees to the estate. That necessarily means that there is a reduction in the value of the estate to be distributed. But if they are coming in after there has already been professional executors in place, and there has been a dispute between those professional executors and a lay executor, then fees will already have been charged to the estate, fees will have been incurred in dealing with the dispute. And you can find that it becomes this cyclical issue, which, if it had been dealt with initially, could have been prevented, or at the very least made a little less expensive for the estate, because ultimately the outcome will be disappointed beneficiaries challenging costs that have been incurred, time being taken dealing with those challenges, which stops the estate being finalised. It also breeds hostility and discontentment with the process, and we can find that where we are approached in those circumstances later down the line, the thought of having to pay more lawyers to step in and deal with an issue is just so unpalatable for the lay clients. And we, you know, we have so much sympathy for that, because it does feel completely futile just to see your inheritance being chipped away by these professionals who, for whatever reason, there's been some disagreement with. The benefit to that, and the benefit to our involvement, is that we can advise on whether costs have been incurred validly and necessarily, and whether they are properly chargeable to the estate. So there can be some recourse there. But as I say, when we are approached at those later stages, it's more about this feeling of no more lawyers. I can't deal with any more legal costs or any more sort of professionals stepping in. I just want this sorted. So that sort of brings me nicely to the reason why we look at these preventative measures. We look at how best to advise people of what may happen in certain situations, and what the kind of worst case scenarios are, so that at the point of referral to us, we understand exactly what the factual background is, and hopefully that referral comes to us, or the client comes to us at an early stage, so that we can mitigate this feeling of hopelessness and futility in trying to resolve an issue that has been long running and hard fought. So what I'd like to do now is hand over to Laura, just to talk to you about how we approach our relationship with both referrers, and where we are approached by the lay clients directly. So I'll just stop sharing my screen and I will hand over to Laura now. Thanks, Laura.
Very much. Thank you. Okay, so as Eleanor says, pretty much any inquiry that comes into us, whether it be via phone or email, it will be picked up by myself or Daniela in the triage team. We are the first people here to answer the phone. We are the people who man the general inquiries inbox, and any client inquiry that comes to us via the refer a client area on the IDRN is also picked up by myself or Daniela. We promise initial contact with the client within 24 hours, but more often than not, we will get in contact with the client within an hour or so of their inquiry coming in. So 9 times out of 10, the inquiry will come in via the client over the phone. Both Daniela and myself, we will make it clear to the client that we are not solicitors ourselves, we're not legally trained, but we are here to listen to them and carry out what we call a fact find. So usually I let the client just sort of tell their version of events, explain to me what the story is, and I will listen and take notes on that. We understand from a non-legal point of view how difficult that phone call is to make. If I was going to be calling a firm of solicitors, I would be a little bit nervous about that too. So I think them understanding that they're not talking to a solicitor yet, it adds an element of reassurance. We're not going to be bombarding them with legal jargon. We're just there to listen and sympathize with their position. So while they're explaining their story to us, we'll be taking notes and we'll be mindful of areas that they may have missed. So we can paint a picture and send that over to the legal team of what their case is. So once they've explained to us what's going on, I will then pose some other questions at them, ask them information that they may have missed, and explain that will be passed over to the legal team and they will get a call back from someone, probably the next day, to provide that initial legal advice and discuss with them what their options are and how we can move forward with that. Following my phone call with them, they'll then get an email from us, which will provide some information about us and our team, what's going to happen next, and who it is in the team that will be giving them a call and at roughly what time. So they're completely up to date and aware of what's going to happen next. From a referrer point of view, approximately 80% of our inquiries come from people such as yourselves who work in the wills and probate sector or have some sort of involvement with family succession planning. Eleanor touched on this briefly earlier, but basically the IDRN was created for our referrers, basically as a thank you for all the work that we receive from them. The IDRN is just jam-packed full of resources and guides and commentary for non-contentious browsing, and basically gives you all the information you need should a contentious case land on your desk. So over the years, we've built some great relationships already with our referrers. And the reason that so many of them trust us to help their clients is simple. We don't compete with you. We offer fee share arrangements. We offer a genuine exchange of client referrals whenever the opportunity arises, and we collaborate with you every step of the way. Because we are a niche area of law, and we only deal with contentious probate, you can be assured that we're not going to poach your client. We can't offer them anything else. So we get involved purely with the dispute side of things, and then the client will always go back to you for more. If the referred client allows it and authorizes us to do so, we will get back to you with a progress update of their case. And we can do that because we use a great case management system called Perfect Portal that allows us to track any email or phone call we have with the client or the referrer. And it allows us to provide that information back to you so we can be very specific about what is happening with the client.
I think something that we do see quite a lot, Laura, is like you touched on that point of contacting a solicitor's firm. It takes a lot of guts for a lay client to ring up a firm.
Definitely.
And equally, there is that element of, even when it comes via a professional referrer, there's that nervousness, there's that nervousness for the lay client to pick up the phone and contact us. So we will always say, even where there's a referred case, we will always say, we will call at a certain time. We will let them know, that it comes from an 0300 number, that kind of thing, so that we're putting people at ease right from the beginning. And that call, that fact-finding call that the triage team undertake is it's sensitively done. We understand that there are huge emotions surrounding these sorts of conversations, and certainly we are alive to the fact that, as Laura said, things might be forgotten, and we will prompt on those points, and we will make sure that we've got all the information that we need to help people. After all, these are real people with real issues who deserve that respect and that time and that sensitivity. And that is something that we offer in every case. There is no deviation from our approach in those calls. And that is why we are able to offer those kind of updates and those check-ins. And we're also able to make sure that where we can't help somebody, they are not sort of strung along, committed into opening a file with us so that we can review their case. We will make those decisions early on, and we will tell them if this isn't something that we can support them on. And we will look to point them in the direction of somebody who can. And that is, again, the beauty of IDRN, that we have this bank of professionals who are trusted and known to us, who we can point people in the right direction for, so that they get that bespoke resolution that they're looking for, particularly if that is not via a contentious lawyer at this point. And that's why it works so well. I've sort of said at the beginning, this is a shameless plug, but this is something we are so very proud of, and we are, so keen for this IDRN to grow, and for there to be more events like this where we can share our experiences, and we can offer you those legal insights and those anecdotal insights into the way that contentious lawyers work, so that we can try to mitigate things for people, and we can try to resolve things as early as possible so that people can just move on with their lives. I think I was going to just touch on, Laura, the fact that we've got there's another couple of events coming up on the sort of preventative measures side of things, but particularly we've got a webinar next week with Radcliffe Chambers, who are a really highly respected set of barristers based in London. We work with them quite regularly, and the role of solicitor and barrister can often be something that's quite confusing for clients or referrers at the beginning stages. You know, who does this need to go to, and then suddenly why is some barrister coming in? What Radcliffe Chambers and IDR are doing next week is basically we're going to be telling the story of a client. We're going to be looking at how the client's journey begins from walking into a solicitor's office to make a will, how things can go wrong, how things can go wrong after that person dies and the estate administration begins, and looking at those points in time or those triggers which, if handled differently, could have prevented this person's estate being a disputed estate, a contested trial in the High Court. And that's why we wanted to get that barrister's input as well on that journey, so that it's not just how the solicitor deals with things, but also what, from the barrister's perspective, what could have been done differently to avoid this becoming so entrenched and so disputed. So that is on Tuesday next week, the 28th. It's me again, I'm afraid, but you'll see me more and more with these sorts of training and webinars, and it is something that I am really keen to develop on. So if there is anything that comes out of this session, or if you join us for the Radcliffe Chambers joint session next week, which we'd love you to, if there's anything that comes up which you think, actually, we could really do with some more in-depth discussion on this, or there's a topic that keeps coming up for you which we could help with, then we'd be more than happy to look at arranging some specific bespoke training on that as well. Otherwise, I hope today has been useful, just talking through those approaches, those commonly, those issues that we most commonly deal with and how we look at those.